I'm Eleanor Hobson and I'm an associate here at Kemp IT Law. Welcome to the vlog. This is the first of 3 short vlogs on international transfers of personal data, which were thrown into the spotlight last year by the Schrems II judgment invalidating the EU-US Privacy Shield. Under each of the EU GDPR and UK GDPR, personal data can only be transferred to a recipient in a third country who isn't already subject to the GDPR if one of 3 instances applies. Now, a third country for these purposes for the UK is any country outside of the UK, and for the EU is any country outside of the EEA. It's worth bearing in mind that a transfer includes anything from storing data in to merely remote access from a third country. Now, the first instance is that there is an adequacy decision that the third country ensures an adequate level of protection for personal data. This decision would be issued by either the UK government for data flows from the UK or the European Commission for data flows from the EEA. Now, for us in the UK, arguably the most important of these decisions are the EU and UK's in favour of each other, as these allow for the free flow of personal data between the EU and the UK. The second instance is if appropriate safeguards apply. The most common example of these are the standard contractual clauses, or SCCs, which are incorporated into the contract between the importer and the exporter. Another less common example used by some multinationals are binding corporate rules, which are drawn up by the group and approved by a data protection regulator. Guidance following the Schrems II decision has meant that further steps also need to be taken to rely on appropriate safeguards for transfers, and we'll deal with these in part 2. In addition, the EU SCCs have recently been refreshed, and the UK has just closed its own consultation into its own SCCs. We'll cover future developments in part 3. In addition to adequacy decisions and appropriate safeguards, the third instance in which you can transfer personal data is if it's covered by an appropriate derogation. For example, you have the consent of the data subject, or you need to transfer their personal data to perform a contract that you have with them. However, even in those circumstances, these derogations only apply to very occasional and limited transfers, so they are rarely available for businesses who regularly transfer data intragroup or to an IT service provider or other partner in a third country. I hope that's been a helpful intro. Please do join me for parts 2 and 3, which we'll be putting on our website, together with other videos and articles on privacy and tech law matters at www.kempitlaw.com. Thank you.